Hello. In this clip from our Justia webinar, Confronting Racial Bias in Jury Selection, Angie Setzer discusses the importance of having representative juries to ensure equality and fairness in the legal process. If you'd like to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Why do representative juries matter? Well, first, representative juries are often the only opportunity for a community perspective to impact the outcome of an individual case. Second, representative juries engage in a more thoughtful and deliberative fact-finding process and are indispensable to fair and accurate trials. And finally, representative juries instill confidence in the legal system. So let's go back to the first point. Why are representative juries often the only opportunity for a community perspective to impact the outcome of a case? This is largely because even though about 40% of Americans are people of color, judges, prosecutors, and law enforcement are disproportionately white. And you sort of saw some of this in the video, but nationally, about 95% of our nation's elected prosecutors, which are about 2,400, are white. And this isn't a statistic that's confined to states with less diverse populations. In fact, what we've seen, and we document this in our report, is that the disparity is often most glaring in communities with the most diverse populations. So California, for example, is a state where the population is about 63% non-white, but only 10% of its prosecutors are non-white. Similarly, Texas, it's a state where about 58% of the state's population is non-white, but only about 13% of the prosecutors are non-white. But it's not just prosecutors. It's judges who are, is overwhelmingly white as well. 20 states currently have all-white state Supreme Courts, including 12 states where people of color make up more than 20% of the population. One example of that is the state we're in, which is Alabama, where all 19 appellate judges are white, even though people of color make up about 35% of the state's population. In 15 states, there has never been a Black state Supreme Court justice. And other groups that have historically been subject to unfair bias and exclusion are also underrepresented. There are no Native American state Supreme Court justices in 47 states, including 3 of the 4 states with the largest Native American population. It's not just state courts either. Federal courts suffer from a similar lack of diversity. You can look at the Fifth Circuit Court of Appeals, where about 75% of the judges on the Fifth Circuit are white, even though more than half of the circuit's population, which is Texas, Mississippi, Louisiana, is non-white. So it's not just judges, it's not just prosecutors, it's also law enforcement, which is disproportionately white. In too many parts of the country, law enforcement agencies don't actually represent the communities in which they serve. We can look at communities in Ohio, Georgia, California, New Jersey, where in some places, the percentage of the white officers is more than 30% higher than the community in which they're employed. The absence of Black representation in these positions means that decisions about who to arrest, which crimes to prosecute, and how to punish people are being made primarily by individuals who have less experience contending with racial bias. Not only are representative juries often the only opportunity to have a community perspective impact the outcome of a case, but representative juries are indispensable to fair and accurate trials. So I mentioned this presumption of guilt and this presumption of guilt earlier, but numerous studies have demonstrated that as a result of this history of racial inequality, people have strong unconscious associations between Blackness and criminality, this implicit bias, right? This makes people of color especially vulnerable to wrongful convictions and unfair sentences. Connected to this, studies have shown that racially representative juries engage in a more thoughtful and deliberative fact-finding process than all-white juries. And the point I want to make here is twofold. First, empirical jury studies demonstrate that white jurors are more likely to view Black defendants as cold-hearted, as remorseless, and dangerous. And they also tend to treat Black defendants more punitively than white defendants. Second, studies have also found that representative juries engage in a more thoughtful and deliberative fact-finding process. They consider more factual information. They're more likely to discuss controversial issues like racial profiling. They're better able to assess the accuracy and reliability of cross-racial identifications, which studies have showed have been subject to error. They're more willing to discuss missing evidence and talk about things they wished had been presented at trial. And sentencing disparities tend to decline as juries become more racially representative. Studies have shown that the more white people on a jury, the more harshly a Black defendant will be sentenced, especially if the victim is white. And this is particularly true in cases in which the death penalty is a possible punishment. In a national study involving capital trials in several states, researchers found that in cases with a Black defendant and white victim, all white juries imposed the death penalty 72% of the time, but only 38% of the time when the jury included a Black person on the jury. Finally, my third point is just that representative juries are necessary to instill confidence in the integrity of the legal system. Discriminatory jury selection violates constitutional rights of the jurors, but it's also incredibly humiliating and painful. And we saw this when we talked with jurors who had been removed from jury panels, jurors like Melody Harris, and we talk about some of these jurors in our report. She lived in Lee County, Mississippi for a decade. She had worked at her job for 6 years, and she was called to serve on a jury. She was struck because the prosecutor said she did not have any ties to the community. And I think even at the time, she knew that she was being treated unfairly. Another example is juror Brenda Green, who lived with her husband in Talladega, Alabama. They both worked for a local textile mill. She actually didn't know why she had been removed from the jury until we showed her the transcript of the prosecutor's stated reason for removing her. And what the prosecutor said was that her husband sold drugs and that she was friends with drug dealers. She was shocked because neither of those things was true. In fact, the only contact she remembers ever having with law enforcement was pointing in the direction that a suspect was running when she was being chased by the police in her neighborhood. The Supreme Court has recognized that the very foundation of our system of justice is our citizens' confidence in it. But it's really difficult for people to have confidence in that system if the jury doesn't represent their community. A 2019 survey revealed that 87% of Black adults believe that Black people are treated less fairly than white people by the criminal legal system, and 61% of white adults agreed.
Thanks for watching. We hope you enjoyed, and if you did enjoy this video, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.